Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor at Faculty of Law, University of Delhi. Moving on to the next part of our presentation, our session today, that is types of void agreement. Now the Indian Contract Act has identified, or you can say has expressly declared, certain types of agreements to be void in nature. So we will be studying, we will be understanding, or you can say going through the various types of agreements which have been expressly declared to be void. First is agreement of which consideration and objects are unlawful in part, that is partially. It is not necessary that the entire agreement, all the terms and conditions of the agreement are unlawful. It may be unlawful in part, which has been dealt with under section 24 of the Indian Contract Act. The next is agreement without consideration. We again have discussed in our previous sessions that an agreement without consideration is a nudum pactum, is a bare promise, right? And section 25 has expressly declared an agreement without consideration to be void. Third is agreement which is in restraint of marriage, which has been described under section 26 of the Act. Section 27 of the Indian Contract Act highlights the agreements which are in restraint of trade to be void. Now agreement in restraint of legal proceedings are termed as void under section 28, followed by uncertain agreements under section 29. Section 30 of the Indian Contract Act declares wagering agreements or the agreements which are in nature of wager to be void. And lastly, we will be discussing section 56 part 1, wherein agreements to do impossible acts have been held to be, or have been expressly declared to be void. We will be taking them up one by one. To start with, the first in the line, first in category is agreement of which consideration and objects are unlawful in part. So we have to understand that there is a difference between section 23 and 24. Section 23, which we had discussed in one of the previous sessions related to consideration, that section 23 lays down as to when or under what circumstances one can say that consideration or object is unlawful in nature, right. So we are talking about an agreement wherein consideration or object is completely unlawful in nature, whereas section 24 is slightly different from 23 because it talks about agreement of which consideration and objects are unlawful in part. Let us see what it reads. It says, if any part of a single consideration for one or more objects, this is number 1, or any one or any part of any one of several considerations for a single object is unlawful, the agreement is void. It is slightly tricky, that is why it has been divided into two parts. So let us see these two parts again. If any part of a single consideration for one or more objects, or any one or any part of any one of several considerations. So in part 1 we are talking about single consideration and one or more objects. So single consideration given for one or more objects, whereas the second part is, or the disjunctive, or is the disjunctive here. So the second part says any one or any part of any one of several considerations. So here we are talking about more than one consideration but a single object. So we are saying single consideration may be unlawful, or one of the several considerations may be unlawful. Similar is the case with object. So a single object or one of several objects can be unlawful in nature, the agreement is void. Now what we have to see is whether a partial unlawfulness or partial basically, if I may say, partially if it is unlawful, then will it lead to the entire agreement being void? That is what we have to see here. So, after having discussed the operative part of section 24, let us see what this illustration has to say. So, A promises to superintend on behalf of B a legal manufacture of indigo, that is the first thing he has to do, first part of the job which he has to undertake, and an illegal traffic in other articles. So, first part of his job is legal, that is he has to supervise legal manufacture of indigo, and on the other hand the second aspect of his job is to take care of or to supervise illegal traffic in other articles, right. Now, B promises to pay, on whose behalf A is about to do this job. So, B is promising to pay to A salary of 10,000 rupees a year. Here it has been held that the agreement is void. The object of A's promise and the consideration for B's promise being in part unlawful. Now, whole agreement would be void. Now, this is what I was talking about, whether the entire agreement will be held to be unlawful, or if we remove the unlawful part, or sever, as we say in law, sever the unlawful portion from that agreement, we have to see whether the remaining portion can sustain its ground. If that being the thing, then the portion which can sustain without the portion which has been severed, then that portion stays. So, it says whole agreement would be void unless unlawful portion can be severed without damaging lawful portion. So, now this doctrine of severability is generally taught in case of constitution. So, whenever we teach our students about the Indian constitution and we talk about various doctrines of interpretation of the constitution, so this doctrine of severability is mostly referred there, wherein we say, so if say for example a particular statute has been challenged as being against fundamental rights, or against, basically it is ultra vires the constitution, then in that case doctrine of severability says one has to see that if we remove one or more of the provisions which have been challenged, will the remaining part of the act survive or it won't. So, if it is capable of surviving in absence of the part which is removed, then the remaining act stays. But if it is not able to survive, if it is not able to stand its ground, then in that case the entire act is declared to be unconstitutional and void. Similar analogy can be drawn here. The second part which we have to take up, or the second type of agreement wherein which has been declared to be void in the Indian Contract Act, is section 25. So, when is stated under section 25. So, when we had discussed, or when we had a session for on consideration, on the topic of consideration, we had discussed in detail section 25, because therein I had told you two things. First was that the opening statement, opening words of section 25 make it very clear that an agreement without consideration is void. And secondly, section 25 highlights the exception to this general rule. So, here for the time being we are only emphasizing upon the first part, the opening words, which say that an agreement which is without consideration is void, reason being that it is held to be a bare promise, because consideration means you have to give something in return of other person's promise. It says section 25, it deals with exceptions to requirement of consideration for a valid contract, and it begins with, these are the opening words in quotes, an agreement made without consideration is void. And there are three exceptions which have been identified under section 25 as I was referring to, which are exception to this rule of agreement without consideration being void. So, these three exceptions are, I will not be getting into the details of these three exceptions because they are not relevant for the purpose of this session and have already been covered under the session of consideration. But still let us just read them. Three exceptions under the provision are dealing with, I have mentioned them in short form to make you understand. First is gift, which is made out of natural love and affection and it is in writing and registered. Second is past voluntary services. So, in our session of related to consideration, we had drawn a distinction between past voluntary services and past consideration also. The third exception which has been dealt with is time barred debt. What do we mean by restraint? Restraint means a restriction, a prohibition. So, few of these agreements which we will be referring to right now will again be repeating this terminology restraint, that is agreement and restraint of marriage, agreement and restraint of trade and agreement and restraint of legal proceedings. We will be taking them up one by one. To start with, agreement and restraint of marriage. Section 26 of the Indian Contract Act deals with agreement which are in restraint of marriage. See, the Constitution of India has granted us certain fundamental rights. So, one of the fundamental rights which we have, you can say available to us under Article 21. So, Article 21 highlights two concepts basically, which is life and personal liberty. So, keeping that in mind, it is generally said that entire human rights jurisprudence in India forms its basis from or gets its origin from Article 21, right. So, it was just to add to your knowledge. Now, coming back to the relevant part. So, under Article 21, we having right to life, personal liberty, we have a right to choose our partner, we have a right to choose whom we wish to marry or not. So, any agreement which is in restraint of marriage, that is which curbs our choice of marrying somebody, it is considered to be or it has been declared as void. Let us see what it states. Every agreement in restraint of marriage of any person other than a minor is void. So, when we say, moment we use this word other than, that means we are saying agreement in restraint of marriage related to a minor is not void. This is an exception here. So, why do we need, why is basically this provision required? Let us see what is the policy of law. So, basically the policy of law or the purpose is to discourage agreements which are restraining freedom of an individual to marry or to basically exercise his or her choice to marry. Restraint, what important point you need to understand is that fine, we are talking about restraint which is a prohibition, but are we referring to a general or a complete prohibition or restraint or even partial or incomplete? Restraint is also something which is void under section 26. So, as you can see on your screens, in both the cases, that is if the restraint is general say we mean complete, or it is partial, that is slightly a part of it, then in both the cases agreement in restraint of marriage is void. Only exception, as we just saw above, is in relation to minor. So, any agreement which is entered into in favor of a minor, which is related to minor's marriage, that is not expressly declared to be void under the Indian Contract Act. Now, there are two examples I have stated, you can see on your screens in the last point, which are saying that if these are the situations or if we are talking about remarriage, then in that case this rule does not apply. Let us see what it says. Agreement that upon remarriage a widow would lose her right of maintenance is not an agreement in restraint of marriage. Not. Second is penalty upon remarriage may not be construed as a restraint of marriage. Remarriage is not coming under this category or this rule of agreement in restraint of marriage. Please keep this thing in your mind. Moving on to the next set of agreement which has been declared void, that is agreement in restraint of trade. I was just mentioning to you that there are 3 consecutive provisions under the Indian Contract Act which use this term restraint. Agreement, we just studied about agreement in restraint of marriage. Now we will be going through agreement in restraint of trade. Section 27 states, and I read, every agreement by which anyone is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. Now there are 2 things I would like to highlight here. So when we say exercising a lawful profession, trade or business of any kind, I would like to take your attention to Article 19 of the Indian Constitution. So Article 19 of the Indian Constitution gives a freedom to the individual to carry on any lawful profession, trade or business. So if we are making any kind of agreement which is in restraint of such freedom, such fundamental right, it is void in nature. But yes, like we have certain, because whenever we talk about restrictions, whenever we say that a person has a fundamental right to carry on any trade, profession, or basically when we talk about freedoms granted under Article 19, we need to know that those freedoms which have been mentioned there are not complete freedoms. There are certain restrictions, but yes, those restrictions have to be reasonable in nature, right. So similarly here, because it says is to that extent void. So the entire agreement, so what we are trying to say here, that the entire agreement may not be void, but maybe a clause or a provision therein is such which is restraining a person's right to exercise a lawful profession, trade or business of any kind. So to that extent that agreement is void. It may not be completely void, to that extent it is void. There are certain exceptions to it. I was just talking about restrictions. So freedom is also not complete. There are restrictions, reasonable restrictions. Here in section 27 also is not completely saying that every agreement in restraint of trade is void. There are exceptions to it. Let us see what those exceptions are. The first exception to section 27 states, saving of agreement, that is an agreement which is saved from the purview of applicability of section 27. So saving of agreement not to carry on business of which goodwill is sold. So it is trying to tell you that if you have sold the goodwill of your trade, of your business, then in that case, and under the agreement in which you have done that, you have sold the goodwill and there is a clause which restrains you from carrying a similar trade, carrying a similar business, that agreement is an exception to this rule that agreement in restraint of trade is void, because as stated under section 27, this is one of the exceptions. To sale of goodwill is an exception to the rule of restraint of trade being void agreement. It says one who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business. You need to understand, it is not saying carrying on any kind of business, to carry on a similar business, because goodwill, we mean that goodwill means the reputation of that particular brand in the market. People know about it, people have awareness about it. So that is what we are referring to when we say goodwill, right. So when a person is selling the goodwill of his business to another person, then in that case he may agree, the seller may agree with the buyer to refrain from carrying on a similar business within specified local limits. That means within the limits of that area, that place wherein the seller was carrying on his business. So long as the buyer or any person deriving title to the goodwill from him carries on a like business therein, provided. Now this is what we have to understand, that restrictions have to be reasonable. So provided that such limits appear to the court reasonable, regard being had to the nature of the business. Now say for example, a person who has sold the goodwill of his business, he was carrying on his business to his business was restricted only to a particular state in the entire country, in the entire territory of India. His business was restricted, yes, brand was a known brand, but was restricted to a particular part of the territory of country. Now if he sells his goodwill to someone, then in that case just think over, would it be correct on his part to put such a restraint or to put such a restriction that the seller cannot carry such business anywhere in the entire territory of India, including that state, but in the entire territory of India that person cannot run this business, right? Just think over, because it says provided that such limits appear to the court reasonable. Will that be reasonable?